Good morning. I'm Jennifer Elrod, and it's a privilege to be here today with you this morning as we begin the panel sessions for this year's convention. Each year, without fail, the Federalist Society assembles a diverse array of accomplished lawyers and scholars who provide insights on pressing issues that confront our nation, the law, and the legal profession. As you can already see from our first panel, the 2014 convention will be no different. Although I could spend the next hour describing the accomplishments of our four distinguished panelists, that wouldn't leave any time for their brilliant discussion. So I will keep these introductions short. Our first panelist, the Honorable Gail Heriot, serves on the U.S. Commission on Civil Rights and is also a professor of law at the University of San Diego Law School. Among her areas of expertise are civil rights, employment law, product liability, remedies, and torts. Commissioner Heriot's work has appeared in numerous law reviews, and she is a former Civil Rights Counsel to the Senate Committee on the Judiciary and former Associate Dean at George Mason University Law School. Prior to entering academia, Commissioner Heriot clerked for the Honorable Seymour Simon of the Illinois Supreme Court and practiced law at Hogan and Hartson here in Washington and also at Mayer, Brown and Platt in Chicago. Welcome, Professor Heriot. Our next panelist, the Honorable Kai Feldblum, has served as a commissioner of the U.S. Equal Employment Opportunity Commission since 2010. Prior to her appointment to the EEOC, Commissioner Feldblum was a professor of law at the Georgetown University Law Center, where she has taught since 1991. She has played a leading role in helping to draft and negotiate the groundbreaking Americans with Disabilities Act of 1990, and she was equally instrumental in drafting and negotiating the ADA Amendments Act of 2008. Commissioner Feldblum was also one of the drafters of the Employment Non-Discrimination Act. After receiving her JD from Harvard Law School, she clerked for Judge Frank Coffin on the United States Court of Appeals for the First Circuit and for Justice Harry Blackmun on the U.S. Supreme Court. Welcome, Commissioner Feldblum. Our third panelist probably needs no introduction for this group. Professor Richard Epstein. He is the Laurence A. Tisch Professor of Law at NYU School of Law. His long list of books includes Forbidden Grounds, The Case Against Employment Discrimination Laws, The Case Against the Employment Free Choice Act, and Design for Liberty, Private Property, Public Administration, and the Rule of Law. I'm sure there are many, many others that I could mention. He speaks and writes on a wide range of legal interdisciplinary subjects, and somehow he still manages to spend a significant amount of time inside the classroom. He has taught courses in just about everything a law school can offer, from an administrative law and antitrust to con law and contracts. He has even taught classes on Roman law. Most relevant here, Professor Epstein has taught classes in employment discrimination and labor. We are always glad to have Professor Epstein on our panels. Our last panelist is Professor J.H. Rip Verkerke. He established and currently directs the program for employment and labor law studies at the University of Virginia School of Law. Before earning his law degree from Yale in 1990, Professor Verkerke earned a Master's of Philosophy in Economics from Yale. While in law school, he held a number of fellowships, including the John M. Olin Fellowship in Law, Economics, and Public Policy. After graduating, he clerked for Judge Ralph K. Winter, Jr. of the United States Court of Appeal for the Second Circuit. Professor Verkerke joined the Virginia Law School faculty in 1991, where he teaches employment law, employment discrimination law, contracts, and a seminar on law and econ. Professor Verkerke participated in an ABA project to draft a new labor code for the transitional government of Afghanistan. We welcome our very distinguished panelists. The format for this morning is as follows. Each panelist will speak for 10 minutes, and then the panelists will have an opportunity to respond to each other's remarks, and then, of course, we will conclude, as we always do, with questions from the audience. The topic for discussion today is youth employment and the law. This panel will examine intergenerational equity issues raised by employment discrimination laws, including those protecting the elderly from discrimination. These laws, as well as the minimum wage laws and laws favoring unionization and laws countering arbitrary dismissal, have obvious appeal. But some believe that these laws raise the cost of businesses to entry-level hiring. One consequence may be that young people are only able to enter the workforce as interns or fellows. This may be especially true for minorities. Are these costs worth the benefits? Is there some middle ground? We look forward to a lively discussion. Professor Harriet?
Remember back, if you will, to Paris about 8 years ago, when the French government proposed reforms to its labor code that would have made it easier for employers to dismiss young employees. Millions hit the street in protest. Cars were torched. About 4,500 people were arrested, most of them young, many of them unemployed. When the youth unemployment rate is officially at 23%, as it was in France at the time, that's obviously a big problem. Just as obviously, the riots did not help. By contrast, the proposed reforms just might have. Granted, they would have made first jobs less secure. An employer would have been able to hire an inexperienced employee, knowing that if it didn't work out, he could end the relationship in the first 2 years, no questions asked, something that otherwise would not be possible in France. But the protesters were wrong to believe that a secure job was somehow being snatched away from them. Most didn't have any job yet, and if they wanted to change that, they needed to recognize laws that make it hard for employers to terminate unsatisfactory employees or make it hard for employers to choose the employees that they want can also discourage employers from hiring, particularly untested job applicants. In the end, the French government backed down. As a result, some of those protesters are probably still unemployed. But while the employment outlook for young people here in the United States is not quite so grim, the further we move towards the famously protective French model, the worse we can expect it to get. Our unemployment rate for those aged 20 to 24 was 11.4% in September, down from a year ago, but still almost 3 times the rate for those over the age of 35. Just to be clear, those figures both understate and overstate the problem. It overstates the problem in the sense that it includes only those in the job market. If you're in school, you're neither in the numerator nor the denominator. It understates it in the sense that it excludes, among other things, those working part-time because it's all they can get, and those reluctantly pursuing additional educational credentials only because they could not otherwise get a job. One hears a lot of overwrought talk these days about a so-called war on women, but if there's a demographic out there that we ought to be worrying about, it is young people, the perennial newcomers to the economy. Well-meaning employment laws primarily benefit those who already have jobs, often at the expense of those who don't. In that respect, they're like so many progressive policies. They help those on the second to the last rung of the ladder, often at the expense of those on the bottom rung. Many of these laws and policies may be attractive or even justifiable when viewed individually, but piled one on top of another, they can become a difficult to surmount obstacle to youth employment. For low-skilled young people trying to get their first jobs, the most immediate threat may be the steep minimum wage hikes adopted recently in various cities. In Seattle, the increase will be over 60%. In San Francisco, 39%. In Oakland, 36%. Now, I believe that Professor Verkerke will tell you that one of the only things that economists used to agree on was that minimum wage hikes kill jobs. These days, however, there are empirical studies going both ways, at least when it comes to modest increases. But if the claim is that the minimum wage hikes generally do not affect employment rates, that's an extraordinary claim. And extraordinary claims require extraordinary evidence. I would rank that one as somewhat more plausible than a study showing that mothers do not love their children, which if someone were to argue to me, I would smile politely and find someone else to talk to, but not a lot more plausible. The notion that profit-making enterprises are insensitive to the price of unskilled labor should not be an easy sell. Not surprisingly, even the studies that purport to justify relatively modest hikes have problems. Perhaps the most famous of them, the Card-Kruger study, for example, waited 8 months before it looked to see the effects. But what we're seeing now, however, is that moving towards increased automation can take longer than that. Last year, Applebee's announced, for example, that it would install tabletop tablets that allow customers to order and to pay without the need for a waiter. Those tablets won't be fully installed for a few more months. More fundamentally, the minimum wage increase studied by Card and Kruger was modest in comparison to Seattle, San Francisco, and to Oakland. It also occurred at a time when the inflation rate was running more than twice what it is today. It would be hard to argue that a 60% increase will not affect unemployment. Recent college graduates face different hurdles, much of which has come to be symbolized in the dreaded unpaid internship. In the book Intern Nation, How to Earn Nothing and Learn Little in the Brave New Economy, journalist Ross Perlin rails against this modern rite of passage, telling interns they have, quote, nothing to lose but their cubicles. His little manifesto urges them to rise up and organize against this simmering injustice. Alas, he misses the point. These positions are not the result of some evil conspiracy. They evolved out of the modern legal and economic environment. Until that changes, a lot of 25-year-olds will be living in their parents' basements. Young people, even with great educational credentials, are unknown quantities to employers and hence risky to hire, especially in a legal environment in which employee terminations can lead to costly legal disputes. School transcripts give very little insight into the job applicant's character and temperament. The proliferation of internships that has arisen over the last 35 years is in part a response to these problems. Now, few would suggest doing away entirely with laws that give legal protection to existing employees. To be clear, that's not what I'm arguing here. I'll leave that to you, Richard. But the least we can do for struggling millennials is to take a hard look at some of the ways in which employment laws, including employment discrimination laws, have backfired, doing no good or more harm than good to those who are the supposed direct beneficiaries. It's not hard to find the backfires, ladies and gentlemen. The hard part is finding a fix that has a political chance of being adopted. Let's start with Title VII's effect on small business. Here's an interesting case study in misdirection, if there ever was one. In theory, Title VII applies equally to hiring and firing. In practice, however, all employers know that they are far more likely to be sued for firing than failing to hire, just as divorcing a spouse is more explosive than declining a first date. This is not what supporters expected when the law was passed in 1964, a time that some newspapers were running help wanted white ads. But consider the irony. The best way for employers to avoid being wrongly accused of a Title VII violation is to avoid hiring someone who could turn out to be litigious if things don't work out. That creates a perverse incentive to avoid hiring the first African American or the first woman in a particular business or department. Skittish small employers worry especially that if a termination of a first becomes necessary, they're going to look bad. A law that was intended to end discrimination in hiring thus ends up encouraging it instead. This is not an easy problem to solve, but don't forget that the original Title VII initially applied only to employers with more than 100 employees before ratcheting down to 25, and now we've been amended to go down to 15. State laws go down to even smaller numbers. There's definitely a case to be made that we'd get less discrimination rather than more by upping it back to 25 or maybe even higher. Alternatively, one could amend the law to further limit the remedies as they apply to very small businesses. Another way to look at the problem may be to allow prevailing employers, or at least prevailing small employers, to collect attorney's fees in the ordinary run of cases. It just so happens that's pretty much what the statute says anyway, but it's been interpreted by the courts to mean something other than that. Here's another impact area that needs a re-examination: disparate impact liability. Ever since Griggs versus Duke Power in 1971, in fact, before that, the EEOC has been telling employers that not only must they refrain from actual discrimination on the basis of race or sex, but they must also use hiring criteria that will yield equal or near equal results for women and minorities, regardless of whether they are consciously or unconsciously discriminating, unless they can prove business necessity. For reasons hinted at by Justice Scalia in Ricci versus De Stefano, I think it's unconstitutional. But more fundamentally, it's incoherent. Every job qualification has a disparate impact on some protected group. Disparate impact makes everything presumptively illegal. This drives everything underground. No employer can state its hiring criteria clearly without risking litigation. You can't even say, we don't hire felons. And God help you if you try to administer any kind of standardized or non-standardized test to your job applicants. There is little or no evidence that all things considered this ends up increasing employment for racial minorities, and that's not because nobody's tried to show it. There is some evidence in the case of the EEOC's policy on ex-offenders that it does the opposite. It encourages actual discrimination as employers try to avoid applicant pools that they believe, rightly or wrongly, are likely to contain more ex-offenders. So if you can hire from the elite college part-time employees for your thing rather than hiring from a part of town where there are more minorities, you've got an incentive to do it. In worldwide competition, we cannot offer employers the cheapest workforce or even the best educated, but we ought to be able to offer greater freedom and flexibility in selecting a team, so long as they are not motivated by race or sex. Meanwhile, too many millennials are stuck in internships by day, living in their parents' basements by night, or are unemployed altogether. Here's hoping that they will understand a little more about the reasons for their predicament and press for reform.
Good morning. So it's a pleasure to be here. I hope I continue to say that after we finish the Q&A. But I actually am very interested in the Q&A session because literally everywhere I go, wherever I speak, I feel like I learned something, and that's what I hope happens here. I also want to acknowledge Lee Lieberman. Is she here? Is she in the room? She is the reason I am here. I think Dean almost gave up inviting me to these, but Lee was a very talented lawyer working in the Bush administration in 1988-89 when she was involved in working on the Americans with Disabilities Act, as was I, and I had various happy and or intense hours of negotiation with her over that law. So this is a panel to think about the impact of employment laws, basically everything from anti-discrimination to minimum wage laws, on youth. That's the topic that we were asked to address. Now obviously what I can talk about is anti-discrimination laws, so I will leave the minimum wage discussion to others. And I'm obviously not here as an economist or an empirical study person. I actually think it's a great idea to have empirical work done on laws after we've passed them, after Congress has passed them. If you can do empirical work before Congress has passed a law, absolutely, right? I will tell you, when I started the Workplace Flexibility 2010 project, which was funded by the Alfred B. Sloan Foundation, so it's a completely business foundation, they felt that there was just an impasse between, that there was nothing coming out of Washington in terms of workplace flexibility issues. And it was true. When I took a look at it, I discovered that there was something called the Family Flexibility Act that was introduced every year by Republicans that simply would have amended the Fair Labor Standards Act to have compensatory time given instead of overtime pay. And that was one goal for flexibility, which was, of course, stopped by the unions and the family groups. They'd like their overtime pay, thank you, not their comp time. And there were efforts towards paid leave. And that was it on the quote-unquote progressive side. There were no other ideas for how to create a flexible workplace that would help lots of folks. Now, the reason I'm telling you this is because of the applause that happened right here by the woman who's now checking her. I hope you're tweeting at the least. Okay, so at least she's tweeting. So one of the things that I said to the Sloan Foundation, which had funded $60 million at that point in research, is if you really want Congress to care about your research, there's got to be some sort of essentially nonpartisan group that is bringing this research to Congress. Because otherwise, the way the political setup works, once you have a hearing where experts are testifying, you're already done. The game is already over, right? Experts are coming to testify on behalf or against something that's already been drafted. So I actually am all about having empirical work done first, but then it has to be good empirical work that is brought to Congress in a nonpartisan, unbiased, objective manner. So I think that'd be great. However, what we're talking about here is a panel on, oh, and by the way, I would not count pure theory as the empirical evidence that would be brought to Congress. Not that I think Richard should not come and testify. I'm just saying, if I were a member of Congress, that's not the basis on which I would be deciding on how to cast my vote. Okay, so I do think, though, that it is important to take a look at laws that have passed to see are they achieving the goal that Congress was intending for them. I think that's fantastic work to be done. Obviously, it can be somewhat complicated because there are lots of variables, lots of elements that might come into play. So it's going to be a little difficult to figure out the causality, right? It might be a little difficult to figure out, is the rise of the unpaid internship model, which is certainly a problem, and there's certainly people suing right now under existing laws, Fair Labor Standards Act, is the rise of that because employers have decided they want to have a time to check out ahead of time if they like someone, if they think the person is litigious. I mean, yeah, maybe some employers are thinking that way, but whether that is the cause as an empirical matter, I would have some questions. So for me, in terms of thinking about any social goal, the achievement of any social goal, regardless of what it is, quote unquote, progressive liberal, conservative, the achievement of any social goal, from my perspective, requires at least 3 variables operating in concert: law, policies and practice, and social norms. By law, I mean the statute as passed by the legislature, let's say Congress, the agency that's been charged with enforcing the law, if there is such an agency, and then the courts. Okay, lots of words. From my perspective, many social goals actually need that first component of law so that they get going. So let's, for example, assume that you don't want young women sexually harassed when they come into their first jobs. Which, by the way, at the EEOC, we actually see a fair amount of this in certain sectors of the economy, restaurants, retail, etc., pretty significant sexual harassment of young women. Well, a law is not absolutely required, right? I'm just saying, as a social goal, to achieve the social goal of no sexual harassment of young women, it is often helpful to have a law that says you may not sexually harass a young woman who's working for you in your restaurant. Now, just even the component of law is itself sort of a dance between Congress, the agency, and the courts, the legislator, agency, and the courts, right? Because all Congress said in Title VII is you can't discriminate on the basis of sex. The EEOC then, in interpreting the law, said that means you cannot engage in sexual harassment, And then ultimately the Supreme Court agreed, yes, prohibition against sexual harassment is part of the sex discrimination prohibition. Sometimes the courts don't agree. EEOC said the sex discrimination prohibition also says you can't discriminate against a pregnant woman. Supreme Court said, no, it doesn't mean that. And then Congress came back and said, yes, we did mean that, passed the Pregnancy Discrimination Act. So even just in law, there's this dance between these agencies, between these actors. So again, I think it is helpful as a component to start with law. But law is never going to be enough. So the second component, from my perspective, are policies in practice. And by that I mean, has the law actually been absorbed by the entities that are governed by the law? Has it really been absorbed into the sinews of that organization? So is there just a prohibition against sexual harassment that they know their lawyers have told them? Or have they really brought that into their organizations in terms of their policies and practices? And let me tell you, lots of companies have their trainings. That's what they do. And by the way, you don't always need a law. Perfect. You don't always need a law in order to have policies in practice. One of the bills that I worked on, the Employment Non-Discrimination Act, I like to say a funny thing happened on the way to non-passage, which is that actually the understanding of sex discrimination has changed to understand that that does include discrimination against a gay person who's attracted to someone of the same sex. And a lot of that occurred because companies put policies in practice before there was any law. So sometimes that can actually then affect an understanding of a law. But finally, and this is where I will end, without a change in social norms, the law won't matter, policies and practice won't matter. If people don't actually believe in their hearts and minds that, for example, it's important for a young woman not to be sexually harassed, it's important for a young person with a disability to be able to be seen on his or her merits, that it's important not to say when you see someone who's pregnant, oh, I don't want to hire that person. If you've got to change the social norms so people actually believe that's the right thing as a society to do. So I will tell you, it doesn't matter how many laws we have prohibiting sexual harassment, although the EEOC will continue to enforce those laws strongly. It doesn't matter how many trainings you have in place saying no sexual harassment. If we don't change the hearts and minds of people on the ground to believe that sexual harassment is not okay, there is no way that one achieves that social justice goal. So I hope wherever we stand on any particular law, unless one can really prove by empirical evidence, not by theory, that that law is actually harmful to achieving the goal, I would suggest to you that we should be working together on laws, policies and practice, and social norms that will ensure that all people in this country, including young people, have the chance at the American dream that all of us deserve. Thank you.
I don't think I will be nominated anytime soon to be a member of the EEOC. And if I had my way, there would be no EEOC to be a member of. Let me see if I can put this into perspective, and I think I'm going to take off Commissioner Feldblum's remark about theory and empirical work. And what you see here, I think, is an absolute recipe for total and complete stasis. We are in a desperate situation now. The basic numbers on youth unemployment are worse today than they were in 1953 at the height of segregation. It's quite clear that the restrictions on labor markets have the effects that were talked about by Gail Heriot in her speech. The law of unintended consequences cannot be repealed by Congress. It is also the case that when you're trying to do this stuff, theory tells you a lot more than empirical evidence in the following sense. When you start to do a question having to do with theory, what you do is you build something of a very simple model. And the simple model that one wants to build is one which says in the end that whenever it is possible to get to something that looks like a competitive market, that's where you want to go. And the reason why you want to go there is that a competitive market essentially exhausts all the gains from trade. So that if it turns out that you have many people on one side of the market buying or selling widgets, and many people on the other side of the market, people will search out, and the fewer the impediments that you have to entry and exit, the more likely it is that people will start to reach ideal kinds of results. You will never get there because transactions costs are always positive, but the influence of the late Ronald Coase certainly matters in this particular discussion. And what Ronald said is the way in which you improve social welfare is to minimize transactions costs. Now, if you start to apply this model to various kinds of industries, in some instances you discover the unhappy truth that competitive equilibria are not possible. But employment industries are not the same thing as network industries. You're not worried really about monopoly practices. So this is an area where the general theory of economics points unambiguously in favor of a system of minimum public intervention. And what you want to do is not find out a way to frustrate contracts, but rather a way to reduce the impediments to their creation. Every time you decide to protect certain people after they've gotten a job, you reduce the probability that they will get the job in the first place. Now, what I said is this is a theory. It's a very simple theory. The second part of the theory is what the way the contracts will look. And here the answer is we don't have any perfect a priori notion of the ideal contract, but basically the norm for all these kinds of arrangements is the contract at will. People should be able to fire or hire at will. People should be able to take or quit jobs at will. And if they wish to get some kind of employment protection, what they do is they bargain for it. And the reason why this particular model works is that reputational sanctions really count, and threats to leave or to hire somebody else really count. So in the end, what happens is employers, employees try to develop ways that maximize the gain, have these relations last, so that what you see characteristically with contracts at will is that many of them go on for an enormously long time, precisely because the gains from trade of both sides are increased by the fact that they have relations with each other and they learn to trust and to cooperate. Now, once you start to introduce the state into this kind of an arrangement, there are three people to every employment contract, one of which has all sorts of opportunities that are simply no part of an ordinary private business. And I don't know which of these social norms I accept or reject, but I can say the following. If you have social norms and you want them to basically enforce, the last thing you ever want to do is to have a law which requires you to observe that norm. Because at that particular point, there is now some third party who could come into the situation, take over the operation of what is going on, and dictate whether or not you have or have not complied with the norm. So instead of having to satisfy each other, you always have to look over your shoulders and figure out what this particular third party wants to do. Now, in dealing with this, we are in a very bad situation today. The youth unemployment numbers, as I said, are terrible and getting worse. Every time we do something to protect youth, we find out that we manage to marginalize them even further. And the explanations are very easy to see. They have relatively low capital. They have to take risks in order to establish themselves. And the only way they can do that is to take jobs from which they can be fired. You deny them that particular option, and they get no jobs at all. Well, how do you do this? Well, you don't do this by creating flex time under the Fair Labor Standards Act and have the unions blow you to bits. What you do is you repeal the Fair Labor Standards Act and recognize it as a failed social experiment which should not be allowed to continue in any way, shape, or form. And then, in fact, employers and employees can decide whether they want to have flex time or overtime. You'll be able to hire people on part-time or permanent basis, but you will not be constantly having to satisfy somebody inside the government whose external norms are not based on anything what you would remotely call empirical evidence. What they are based upon is some a priori vision of what they regard to be the just society that they're prepared to impose on everybody else. So take something like discrimination laws. Is it really the case that we're absolutely positive that anybody who decides to discriminate on any grounds, race, sex, and so forth, is in fact inappropriate? I don't think that's the case at all. It may well be that in certain kinds of jobs, women do better than men. It may well be that there are conservative, consumer preferences that actually matter in these particular cases that you're trying to satisfy. If you let the sorting take place, it may well be that you will run an affirmative action program free of government complications. It may well be that you're going to do exactly the opposite. As far as I can tell, what Kai Belbum said is really true in this case, is there are many instances where you find out that firms are running far ahead of the government in the way in which they deal with certain complicated interests, like, for example, gay rights in the workplace and so forth. Well, the reason why they're running ahead of government is they have the right set of incentives when they're trying to run mass businesses to figure out how they can attract a very large workforce. And the government has no such incentives because they're never involved in any case in which they hire or fire. And I remember years ago, a friend of mine named Bob Lamont, who ran a very large company, said, look, 35% of the workforce is white male, and I've got to hire God knows how many people every year. I can't just concentrate on that group. I have to make this place congenial to everybody, and if I don't have people in my workforce who can work with anybody who comes in, they're no good to me. Well, this is a way in which you can enforce a non-discrimination law, which really matters because the employer sees it, you can imbue it in the way in which you operate it, and you don't have any government telling you, well, you've done the right thing, but you haven't done quite enough of it, or you haven't done enough of it to satisfy us. So let me just end on this particular kind of note. Empirical evidence, the various studies that Rip Kirky is going to talk about, they will always tell you a little bit of something. And what will happen is every one of them can be qualified in a particular way. But if you're trying to figure out what the basic tendency is, the first presumption is freedom of contract is the dominant norm, and there's a very heavy burden of proof, particularly in labor markets, that should be imposed upon those individuals who wish to interfere with it. That is a message which is not heard in Washington. So what we do is engage in this ugly cycle. We've put one set of restrictions in place, and we discover that unemployment rates get higher. We never decide to repeal what's already there. We just add another one on top of that, and another one on top of that. And as Gail Heriot said, and said correctly, individually these things are bad. Together they have negative synergies. And if you want to look at loose employment rate, remember what Moses said, let my people go. And they'll do well enough on their own. Thank you.
You've got to be kidding me. I'm not going to try to match Richard in any respect. This is the boring part of the panel today. I do want to thank you for the opportunity to participate in this important discussion. So far, you've heard some critical perspectives on labor regulation. Professor Heriot and Professor Epstein have explained how increased firing costs and a kind of wedge of protective legislation reduces demand for labor. And those effects are particularly pronounced for relatively less skilled and inexperienced young people. I'm going to respond to those arguments in three ways. First, I want to explain why economic theory does not unambiguously condemn these regulations. Second, I hope that we can agree that concerns other than economic efficiency could drive public policy in this and other areas. And then finally, I'll show that the available empirical evidence casts considerable doubt on the argument that labor regulations in the US currently reduce employment opportunities for young people. So let's begin with economic theory. Arguments about the inefficiency of government regulation intervention in the labor market routinely assume a perfectly competitive market. No one exercises monopoly or monopsony power. It's also necessary to assume that workers have full information about the characteristics of jobs and firms. In addition, workers must be able to move freely among jobs in order to impose market discipline on those firms that treat workers poorly or fail to pay them well enough. And finally, there must be no externalities affecting employment or subsidies that distort labor supply or demand. These conditions are rarely, if ever, achieved. Traditional company towns, admittedly, are now quite unusual, but a few still exist. But more broadly, job mobility has long been hampered by location-specific investments. For example, home ownership, family ties, spousal employment, And the lock-in effect of company-provided health insurance is another significant force, now diminished somewhat by the provisions of the Affordable Care Act, but still a significant impediment to job mobility. Information about firms can sometimes be adequate, but is often incomplete and imperfect. And many subsidies and externalities influence both labor supply and demand. For example, the Earned Income Tax Credit, food stamps, and other income supports, as well as the charity care provided by most hospitals, allow firms to pay lower wages than they would if these measures were absent. Similarly, companies of all kinds receive a vast array of subsidies, both direct payments and tax incentives, that dramatically alter their demand for labor. There's no realistic prospect that those payments will be eliminated, regardless of which party controls Congress, or the presidency, or both, for that matter. These departures from the ideal conditions of a competitive market undermine the claim that any specific policy intervention will distort a pre-existing efficient competitive equilibrium. Indeed, the general theory of the second best, according to the general theory of the second best, it's not even possible to say whether removing any single distortion will move the market closer to efficiency. As I've already said, I hope we can also agree that public policy might legitimately pursue goals other than economic efficiency. For example, there's an ongoing debate about the importance of income inequality in contemporary society. Many people believe that principles of distributive justice require some form of social safety net. Others advocate for more aggressive redistributive measures. Wherever you stand on this issue, it's difficult to deny that we often legislate to protect dignitary interests or to express approval or disapproval of conduct on grounds that have nothing to do with efficiency. Thus, for example, a coherent defense of anti-discrimination law could rest on the expressive function of these laws. Prohibiting discrimination on the grounds of race, sex, religion, age, disability, or sexual orientation expresses social disapproval for these discriminatory practices. The goal of the law may be, in part, to eliminate inefficient co-worker discrimination on these grounds. That's an efficiency motivation. But for many advocates, the goal instead is to shift social norms and transform our culture into one that rejects these discriminatory attitudes and preferences. It follows that economic efficiency is neither a necessary nor a sufficient condition or argument for or against a particular regulatory measure. What then does the available empirical evidence tell us about youth employment and the law? The topic is vast, and our time is quite limited. So I'll focus today on just a few findings from the empirical literature that cast some light on this question. I'm more than happy to add further discussion during the Q&A or our panel discussion as well. We've heard some criticism of age discrimination laws, wrongful discharge protections, minimum wage laws, employment regulation in general. Empirical work tends to focus on one law at a time. So what happens, for example, if to younger workers when the law protects older workers by, say, outlawing mandatory retirement or overt age discrimination? Sadly, no one has tried to answer that question. Sorry. That may be because empirical studies of age discrimination law have found either no effect on the employment of older workers, or at most a modest improvement in their employment prospects. If the law isn't making a measurable difference for older workers, it's hard to see why it would adversely affect younger ones. But is that even the correct way to think about this problem? Is the labor market a static, zero-sum game in which gains for older workers necessarily impose losses for younger ones? That's a question economists have tried to answer. A book by Gruber, Milligan, and Wise, published in 2010, studies the retirement incentives in Social Security law. Those incentives are precisely the obverse of the incentives that age discrimination laws and wrongful discharge protections create to retain older and incumbent workers. The hypothesized effect of employment protective legislation on youth employment operates through the same channels and thus stands or falls with the effects of Social Security retirement incentives. The key question in Gruber, Millikan, and Wise is whether the departure of older persons from the labor force expands job opportunities for the young. The unequivocal answer is that the available evidence contradicts that theory. The departure of older workers from the labor force in no way helps younger workers obtain jobs. These authors emphatically reject what they call the lump of labor hypothesis, that is the static zero-sum model of the labor market. And in further support of that conclusion, they note that labor markets were able to absorb a huge increase in the labor force participation rate of women over the past 40 years, and employing more women doesn't appear to have reduced opportunities for young workers in any way. There's no correlation between prospects for youth and the degree to which women increase their labor force participation, and that pattern is consistent across a large sample of industrialized countries with quite diverse types of labor regulations. What seems to matter most, instead, to youth employment and unemployment and the employment to population ratio, is aggregate demand in the economy, rather than any fine details of employment regulation. But maybe the implicit model of critics is not that the old need to get out of the way and make room for younger workers, but instead is based on the idea that firing costs act as a drag on productivity. I've recently reviewed the extensive literature about employment protective legislation and employment. The punchline here is that the evidence is thin and the effects are very modest, unless the regulations are quite extreme, as for example in some Latin American countries studied in an article by Heckman and Pagas. Interestingly, youth unemployment is exceptionally low in Germany, despite notably strong protections for incumbent workers. Also note that unions in Germany have far more power than US unions did, even in their heyday, and the German minimum wage is considerably higher than ours. Instead, it appears that Germany's aggressive apprenticeship program is a far more important determinant of youth employment than any of the regulatory measures that we've heard criticized. Evidence on the effects of employment protective legislation in the US is mixed. The best available estimates from Autor, Donahue, and Schwab suggest very modest disemployment effects, but the magnitude is far too slight to produce anything like the unemployment issues that we've been discussing here. And recall that the cross-country evidence suggests little connection between employment of the young and the old. The dynamics of the labor market appear to separate these two groups in different categories. The old and the young just aren't very substitutable for one another in the labor market. They are largely competing for different jobs. So that leaves us to ask, and I will try to wrap up briefly since I know my time is over. Thank you very much, Judge Elrod. So that leaves us to ask how all these regulations really do affect human resource practices. Consider termination and hiring. What determines firms' behavior? My discussion here is more anecdotal and speculative, but it's an empirically informed speculation. Let's start with termination because the available evidence about litigation suggests that these claims focus on wrongful discharge. In the era of modern HR management, firms have embraced a norm of just cause for termination. But that norm arose to maintain employee morale and protect firms' valuable investment in personnel rather than in response to legal regulation. Even so, regulation imposes some additional costs. Firms take preventative measures in the form of more extensive documentation and some delay in executing discharge decisions. Defense costs and potential legal exposure to damages are a burden, but they affect a very small minority of discharges. What then is the net effect on opportunities for young people? That's a hard call, but the available evidence suggests that the problem is not that incumbent workers aren't being fired. A more plausible candidate would be shortfalls in aggregate demand and skill-biased technical change. Entry-level jobs increasingly require more education and training, and global macroeconomic shocks, including the Great Recession, have depressed demand for labor. Turning very briefly to hiring, we can rely on empirical evidence about patterns of firm behavior. There can be no doubt that firing costs influence hiring decisions to some extent, but patterns of hiring and economic development suggest strongly that these costs are decidedly secondary. First, we see an incredibly strong cyclical pattern to hiring. Good economic times easily overcome employer reluctance to hire, and vice versa. Second, jurisdictions with stringent regulations, for example, California or Germany internationally, experience robust growth despite what must be comparatively higher firing costs. Within the US, we'd expect few employment opportunities in California, but we see many. Internationally, Germany should be in terrible shape, but their labor market is doing comparatively well, especially for young people. I have little doubt that government can regulate the labor market so stringently that legal rules will chill economic activity and depress employment. But there is no convincing evidence that US regulation is anywhere near that point. I readily concede that greater labor market flexibility helps economies adjust to macroeconomic shocks, though sometimes at the cost of imposing large losses on relatively vulnerable individuals. But US labor regulation is quite lax compared to other countries that are doing quite well at employing young people. Nothing I've heard today convinces me that repeal would substantially improve employment prospects for youth. Thank you.
As promised, we will take a few minutes for any comments by the panel members about the statements made by the other panel members. Professor Harriet, did you have anything that you wanted to say? Or?
I guess I'd like to comment on Germany. You know, it's interesting, and the way I see it, at least, the saving grace of our economy is competition. You know, if you don't like what your employer's doing to you, you go out and you get another job, and there are lots of employers out there. The thing about the German economy that's quite fascinating, you know, again, unions are very strong there. The apprenticeship programs, I think, are admirable in many ways, but it's like the other side of the coin. You know, you can't have these apprenticeship programs as effective. They're not as effective here because we have free labor, and therefore employers don't want to train employees because they know the employee can go somewhere else. The strong unions result, I think, in better training for vocational, but you're stuck with that union the rest of your life, and God help you if they don't treat you well, because you need to be with that union. And so I think it's a problem for our economy that we don't do as good a job with apprenticeship programs. We don't do as well with vocational training. And you know, we've got to be better at that. But if the way to solve that problem is to have you know, commit for life to a union that may or may not treat you well, then that's a very high price to pay for that. So right now I'm figuring I'm much more willing to stay with the American system. I hate to use this metaphor, but we whooped them twice in world wars. Whoop them again. I mean no disrespect to Germany, a country that I in fact do respect.
Okay, I won't comment on that. Although as the daughter of a Holocaust survivor, I am very glad that I was able to be born here. So I want to comment on Professor Epstein's sense of if you have a social norm you want to enforce, the last thing you want is a law. So I just want to clarify, I think what might be helpful is the difference between at least what I was referring to as a social norm versus a social justice goal, a social outcome. As I said, to me, a social norm is what's in the hearts and minds of people. What does the hiring manager on the ground think is the right thing to do in society? You know, what does the coworker in the restaurant think is the right or wrong thing to do? In that respect, in social norms, there's just no way that if you want to do that, that you pass a law. I'm passing a law telling you think sexual harassment is bad. You know, I'm passing a law that says you need to accommodate a young woman coming in with a hijab, and I want you to believe that that's the right thing. I mean, that's crazy, right? However, you might have a particular social justice goal, a particular outcome. You might want that a young Muslim woman wearing a hijab is able to have a job in a store like Abercrombie & Fitch that ordinarily says you can't wear any head coverings, right? You might want as a social justice goal that a person with a disability gets an accommodation someone gets a ramp, someone gets a sign language interpreter, right? You might want that. You might not want that as a social justice goal, in which case, all of these laws, of course, have no relevance, right? But I'm going on the assumption that there are certain social justice goals that you want. You may want someone who gets pregnant not to be fired. You know, you may want a young woman not be sexually harassed. Clearly, Congress had all of these social outcomes in mind when they passed these laws, right? That was their goal, was to achieve these outcomes. What I'm saying is that often a law is essential because, with all due respect to market competition, I don't really know that someone can go in there and bargain not to be sexually harassed, bargain to say if I get pregnant I won't be fired, bargain to say, oh, I know you have this policy of no head coverings, but I want to wear my hijab. I mean, in some cases maybe, but I think Congress's assumption was the market will not take care of those issues. So again, the law simply says there's the prohibition, but I think we can bring as many lawsuits against Abercrombie and Fitch as we want, but ultimately to allow the young woman with the hijab to wear her hijab and have that job, I think we need the combination of the law, the policies and practice, because Abercrombie actually changed their policy to say, yes, generally no head coverings, but please make accommodations for religious needs. But then at the end, the person on the ground has to believe this makes sense. Otherwise, they're not going to be following the policy. And I believe I have a good setup for Professor Epstein now.
Oh, you certainly have. Look, I think
My
the
job
two
in life.
most dangerous words in the English language, to just pick up on this, are the word Congress and the word you. And the first of them, what you're doing in both cases is you're finding issues which are highly contentious, for which there is much disagreement, and then you're saying this sort of generalized you agrees with it, and then you're saying Congress does. So just for example, say, on the one hand, we all believe that you should hire without regard to this, that, or the other thing, and then the second thing is we all believe in affirmative action. They're obviously in tension with one another. The point about a market is markets don't decide anything. It's decentralized actors who decide things within the framework of markets, and there's nothing which says they all have to go the same way. So you talk about hiring pregnant women. My view is the Pregnancy Discrimination Act is a giant-sized mistake. In some firms, the cost of hiring pregnant women will be very low, and in fact, employers will make all sorts of adjustments to keep able employees who are pregnant far beyond what the law requires. But in other kinds of jobs, if you have to keep a position open during a peak season and a woman is not there, the costs are extremely high. And so what you're doing is you're creating an environment where the so-called non-discrimination world means that employers have to enter into contracts which they regard as losing agreements for themselves because you and your great wisdom sitting on the commission say this is a social objective that you have, which frankly, my dear, I just don't share. It's not that I think it's wrong in my business, it's just that I don't think you or anybody else should tell everybody else how to run their businesses in accordance with a set of norms that you and only you and the Congress knows. The point about a consensus, I want to be very explicit about this. The point about a consensus, if you have it, you don't have to make it unanimous. You can run a perfectly fine world in which 80% of the world agree with you and hire in accordance with your standards, and the other 20% go in the opposite way. And so what happens is the you essentially becomes not a norm of freedom, but a norm of totalitarianism. Now, I want to say something about Rick Fitkirky, because very violent disagreements here. And the first of them is you do not want, when you're talking about
Don't knock him off
markets,
the stage there.
I'm just going to make one of many. But the first move is the wrong move. Of course, there's no such things as perfectly competitive markets anywhere. But the question you then ask when you're faced with these imperfections, what do you do? And there are two ways to go. One of them is you to try to get rid of some of the things that distort. And the other thing that you do is you allow intermediaries to come in there so as to broker information gaps and all the rest of it. There is nothing whatsoever about imperfect regulation or perfect competition that justifies monopoly regulation which is imposed by the state. Now, the question of how serious this is, we can have a real fight about that, but I'll give you one industry in which the age discrimination laws have absolutely devastating effects, and I'm in it. It's the academic business, where all the things that you have to do with respect to hiring people over the age of 70 has completely whacked up this market. And what we do is we keep people long past their productivity stages, and we can't hire younger people in there. And my own view about this is I'm still in the market, but frankly, one of the reasons why I quit was because you go back to the market and you prove yourself again. The situation that everybody now regards as efficient as a matter of public law is, of course, so efficient that every private institution will buy people out of their contracts at their given tenure precisely because the contract arrangements that you have are madly inefficient. In most markets, people want to retire early. That's fine. There are other inefficiencies. But you have to figure out not what the effect is on age unemployment. The question is the effect of coercion. There's no good that comes out of that statute. They cost a lot of money. The fact that there are other things that influence market, which is the nature of the argument, is certainly true. But it's not a case for keeping this stuff. It's a case for getting rid of not only this stuff, but a lot of other stuff out there, which we don't need either.
Well, I don't want to fight with Richard Epstein, particularly in front. You have a lot of seconds, I understand.
I'm willing to go to the ACS. I mean, you know, just send me an invitation.
So one quick response to what Richard just said about the academic market. One thing that's quite unusual and distinctive about the academic employment market is tenure, and so the difficulties, if you will, of having workers leave at whatever appropriate age of their productivity decline, if your assumption is that their productivity is declining with age.
That's me.
Yeah. Is a distinctive one as a result of both the presence of tenure, which is not that level of job protection is not present in the rest of the market, and secondly, the very, very generous defined contribution pension plans that professors benefit from, and the incentive that creates for them to stay on. There are definitely ways to move people out. I guess so. I want to take just a quick shot at the at Richard's assertion that the best remedy to these various discrimination laws particularly is to get rid of as many of them as you can. I mentioned the general theory of the second best, and that is so the theory on which we're both relying is, yeah, Richard has something to say.
I hate the second.
Yes, I know. But the principle that we can move towards efficiency by getting rid of several of many potentially influences that point in the direction of inefficiency is just, that is not an assertion that one can make. That becomes an empirical question. There's absolutely no way to determine a priori that removing piecemeal. Now, of course, Richard's program, of course, is to remove all regulation, right? So he does have a defense in that regard. I'll make two responses to that. One is that that program is a political non-starter.
So what?
Yeah, okay. Fine.
This is an academic debate. I mean,
it's not.
Sure it is. I mean, we're in Washington.
How many academics are
No, I mean, we are having a debate as a matter of principle. What they allow us in Congress to do is something we're trying to influence by changing ideas. But if we kowtow our proposals to their idiocies, we are doomed.
Okay.
My role is clearly to set up Richard for applause lines.
Well, just don't make these mistakes.
So one last observation, which is, whatever, I mean, this is an argument that we've been having for actually 24 years.
Yeah. You reviewed my anti-discrimination book.
I did.
Unfavorable.
Okay.
Yeah.
Professor Furkirky.
But leaving aside that theoretical debate, I think the point that I'd like you to take away from at least my remarks is that in order to, it's very easy to make assertions about the effect this burden on business is causing this effect in the labor market. It's much, much harder to show that that's actually happening. And so if you have a faith-based empirical policy, like your attitude towards empirical evidence is faith-based, then fine, I'm not going to persuade you. But I have the sort of drive of a social scientist to try to measure these things. And to the extent that we've tried to measure the effects of employment protective legislation in the US, the effects are actually rather small. It's difficult to find them, and the asserted catastrophic influences that we've heard simply aren't borne out in the available empirical evidence. And so that
Richard,
strikes me as the problem.
Yeah, before you respond, Richard, so I have just a short question. How many people here believe in American representative democracy? Please raise your hand if you believe in representative democracy.
No, we believe in
Please raise your hand high. Okay, how many people here do not believe in representative democracy? Anyone? Okay, a few. And I just wanted to ask you that in response to what Richard said, that he didn't believe that people at the commission, for example, should be deciding what is the right social justice outcome. I want to completely endorse that position. It is not my job or any of my colleague commissioners to decide what we think is the right social justice goal. None of us have been elected by the American people. None of us, okay? Our job is to enforce and implement the laws that Congress passed. And I will tell you, in my 4 years, I have completely abandoned the role that I played for 20-some years, where I was an advocate for particular groups and I was pushing for certain things. Now, my job is to apply the laws as Congress enacted them. So if Congress decided that pregnant women should not be discriminated against, that's our job to enforce it. If Congress decided there should not be discrimination based on religion in the workplace, our job to enforce it. It is American representative democracy that decides what social justice outcomes we want. It is not individual, unelected members. Thank you.
I don't want to decide it for America. I just want to decide it for my own business.
They passed words, which, as Justice Scalia said often, it is the words of Congress that we are governed by, not the intent, not the words. That is what I will tell you. I am a textualist myself in terms of how I apply things. I go by the words. If Congress doesn't like how it works, Congress can change it.
Well,
right? They say it's better to say, let the market decide about whether.
Not to throw the words back in your face, Your Honor, but
just we're not quite
okay,
taking questions yet. We'll be taking questions in just a couple of minutes, and you may go ahead and line up, and you need, and just to give you guidance, you need to pick your best question and make it a question, not a soliloquy, so to speak. That goes for everybody, and I'll try to do the same. Professor Epstein, you had something that's you're dying to say.
I'm just dying to say it. I cannot think of a single statute that has been tortured beyond its original meaning more than Title VII. Briggs itself is a total and complete blunder in terms of statutory construction. The stuff on pensions, completely misread. The evisceration of the bona fide and bona fide employment, all of that stuff is just gone. The labor statutes, bad as they are, basically stayed where they were, but the discrimination laws have gone far beyond. That's the first point. The second point to Rick is there is a very simple way. When you are trying to figure out the effect of a law, what happens is the law itself is done with some respect to realities. So if a minimum wage law is always going to be very close to the market level, you're not going to see much of effect. When you move it 60%, you are going to start to see that effect, and the past up won't do it. You want to see a law with effect, try rent stabilization and rent control in New York, and then tell me there's a second best justification for that kind of stuff. There is. Either you get rid of this thing, or what happens is every time I have a reform, he's going to say it's a second best type situation. It's not that he knows what's the right answer. It's he says that I don't know the right answer. Well, I say the consistent right answer in all these cases is liberalization, and you want to get rid of laws that have no effect precisely because at some future time they will.
Thank you. Thank you. I have just a couple of questions, and you can pick one or neither of them to answer. And it turns us back to our to youth and employment. Should we be guided at all by the studies on like the Davis-Bacon Act that had such, according to certain Congressional Joint Economic Commission, said that it had a severe impact on youth and minority employment? Should that be a guiding factor when we're looking at empirical evidence of previous enacted laws? Does that help us in any way? Perhaps that's
I'm asking to do things like that where we have impacts, that certain laws that were passed in employment and that they had an impact. Can we analogize to say that these are also likely to impact youth and employment? And my second question, which you can pick this one instead, one of the main big proponent of the raising the minimum wage to $15 an hour, Robert Reich, has said that raising the minimum wage will attract more workers into the job market because employers will have choices of whom to hire and therefore have more reliable employees, resulting in lower turnover costs and higher productivity. Doesn't that choice of whom to hire actually make the point that Professor Epstein is trying to make and Professor Harriet is making? Because if you're choosing whom to hire, it's the youth that are not so reliable, perhaps, that are going to be left aside. And those are my questions, and anyone can answer them or not answer them.
So, no, why is everybody so shocked?
Professor Epstein.
Go ahead, Richard.
I'm not sure. Look, the Davis-Bacon Act is one of the worst statutes in the history of Western civilization.
Except for all the other worst statutes.
No, this one is even worse. Its stated purpose was to make sure that colored itinerant workers from the South could not come up to the North and do competition with white unionized laborers. If somebody wants to defend the statute with that pedigree, be my guest. The second thing is, the single worst economist in the history of Western civilization has many contenders, but Robert Reich is certainly one of them. If employers want to get reliable workforce by $15, it's not as though anybody prohibits them from offering something above the minimum wage law. In fact, one of his problems is he can't figure out why any employer would ever do such a foolish thing, except for the laws of supply and demand, which he really doesn't believe in. And so you have that option right now. Forcing people to do something restricts employer options. Why that is a good, maybe Professor Reich will explain to us, but I doubt it will be very persuasive.
I agree completely about the Davis-Bacon Act, but I don't agree necessarily about Robert Reich. But in any event,
you're just too kind.
Yeah, a proposal for a $15 minimum wage, even on the empirical evidence that I've been discussing and that is available, would in fact have significant disemplopment effects and probably mostly concentrated on unskilled youth. It's a complicated, it is a complicated question whether they're better off in low-paying jobs than they are, for example, in school, which is where they'd likely end up, or alternatively, if they would end up in criminal activity or idleness, which clearly would not be good. So I think there's still some ambiguity, but I would suggest that the evidence that I've been talking about has to do with minimum wages of the sort that we have now, which bind roughly 2 to 4% of the workforce, and for changes of a modest amount rather than of an enormous amount. So, so that's as far as the empirical evidence will take us, and I want to be clear about that.
I just wanted to comment about the $15 minimum wage and it drawing out people who might not otherwise want jobs. You know, if you have to pay $15 an hour, you don't want like an 18-year-old kid who really needs to be trained into the ways of the workplace. What happens is that sometimes you will draw out retirees who, it's fine. It's a lovely thing if you're a retiree who wants to get a job at McDonald's. But if I'm worried about youth, I am more concerned about the fact that now there are young people that are unemployed that used to be able to qualify for those jobs but can't now because now you need a physics degree to get a job at McDonald's because it pays so well, or some level of credential that is really quite high.
Okay, we will take questions now.
Lisette Garcia, small business owner of the FOIA Resource Center. I find it impossible to pay people those rates and train them to actually teach them what I do. But that aside, the proposition was raised about studying legislation to see if it doesn't work before repealing it, rather than just putting it to popularity, which is America, democracy. How do you feel about doing the opposite, doing performance reports just like we expect of government grant recipients, doing performance reports on things like the Urban Youth League, whatever it is that they, these programs that are designed to like educate and train, whatever, and doing more performance reports on that in order to repeal laws that just suck money off of government?
Actually, there's probably more, there's a significant amount of performance review that goes on in the federal government in terms of federal laws and programs. I'm assuming a fair amount goes on in the private sector as well, because it just would make sense to do it, but those don't become public knowledge. I mean, the whole point is to do it and then I think keep it somewhat confidential inside the company. But in the federal government, I mean, the combination of various oversight activities by the various committees, the GAO reports, you know, that are done, the work from, like I said, I think that one's job when one gets into an agency is to, in fact, you know, under Title II of the Constitution, to execute the laws, to help execute and implement, which requires, from my perspective, taking hard looks at whether they're achieving their purposes. So I actually think the concept of doing that is certainly smart. I think it's actually accepted by a whole range of folks. How effective it is, I don't know. I mean, I spent most of my career in academia. When I came into the federal government, which was just 4 years ago, it was like a different country. I felt I should have gotten a passport and a dictionary. Because I mean, it was just so different. And part of it was because it was very large. It's a big job. It's the largest employer in the country. I mean, so I think that the concept of doing those, you know, analyses and reviews is something that is absolutely bought into. Do I think it can be more effective? Absolutely.
Can I say something?
The government is too big, so it's diseconomies of scale, not economies of scale. And one of the reasons why you want to have some deregulation is because you can then get rid of the stuff which is completely counterproductive, like the EEOC.
One thing I want to say is that a lot of these performance reports need performance reports. That, you know, there's an awful lot of stuff out there that is really shockingly shoddy, purporting to report on the performance of various government agencies, government policies, or whatever. You know, I sit on the U.S. Commission on Civil Rights, and so I'd have to say that our commission does not always do a great job in evaluating federal policies. But sometimes we do, though, so I don't want to be too hard on them. But you know, what I would like to see is more sunset rules. You know, you pass a statute and you say this is going to be reviewed at some point, and Congress is going to have to repass it if they want to keep it. So that's something I would very much urge Congress to think about when they pass a statute. Make them repromulgate it 5 years later, see if they still like it.
There's two mics. You want to go down there first?
So I have a question for the panel about how large corporations have responded to this regulatory regime. I've somewhat recently become in-house counsel for a really large American business, and I'm struck by the power that our HR department has. And the just absolutely maddening difficulty it is if you try to hire, for example, some sort of a high achiever, or high performer, or top executive, and they're not willing to sign the boilerplate that HR puts in front of them. And I mean, I've discussed this with colleagues that are in corporate counsel positions elsewhere, and they have a similar feeling. And I wonder if that's a response to regulation. Is that a fear of litigation? And if you think that, you know, that issue is also, you know, coming from this regulatory regime.
Could you clarify what boilerplate you have in mind? Is this a mandatory arbitration provision, a non-compete?
Yes.
Yeah. So
I mean, I've seen it run the specter. You know, even things such as you know, deciding about even compensation issues and stuff, about, you know, how many days of vacation or things like that, and you know, things that when I worked in private practice at a firm, we'd go, yeah, no problem, this is no big deal, and now the HR department goes, oh, but we have a policy, and if we don't follow the policy, we're certain to get sued.
Yeah, I would say that's bureaucratic human resource management, but the specific policies that you mentioned, for example, confirmation of at-will status, is a response to implied contract claims, and it's a very, very effective response to those claims. So they're routinely enforced, and there's really, it establishes an at-will relationship, at least within contract. The mandatory arbitration provision is a response, and probably includes a class action waiver, is a response to a recent line of Supreme Court cases that have read the Federal Arbitration Act to pretty aggressively to preempt state laws that would have made those questionable. And whatever you think of them, it is definitely a response to that line of cases. Non-competes are another issue, more complicated.
Look, the single most important development, the good development in employment relations law is that when you actually say we mean at will, it will be enforced. And that's one of the reasons why it turns out that American labor law doesn't have quite the contours of Germany. When somebody says that, you know, deregulation will improve matters, the argument here is that not that it's going to make it better than Italy, Germany, or France. We're already better than that. It will make it better than it is right now. And what we're trying to do is to get some degree of incremental improvements, and we're not trying to figure out how it is that we emulate the failure models that we see all the way over Europe, which are in cases of genuine crisis at this point, and it all starts with their labor markets. We are nowhere near there, and God willing, we will stay where we are relative to them. Oh, you don't have to.
Okay. Did you have a question?
Go ahead. Could I comment on that? The bureaucratization of hiring in large corporations, I think, is a hugely important issue. Human resources offices have huge power. And I think the inefficiencies that are created by this are very much neglected. An employment relationship between, say, supervisor and employee, the close relationships, you know, those are very personal relationships. The person that you hire to be your assistant, you know, that's a very personal relationship. And what we wind up with now is situations where hiring is so controlled by human resources offices that it's the source of inefficiencies, I think, that have not been measured and cannot be measured. It's just too difficult to measure. But I think it's huge, the amount of power that human resources offices, how we've professionalized hiring and generally dealing with employees, I think, in ways that are very counterproductive.
You've been very patient.
Oh, no problem. I'm Mike Doherty. I'm the CEO of LabMD, and until a year ago, I employed 40 people in a medical facility, which is a petri dish of social change. Since we have Obamacare and HR, and I would say, speaking from that, I found that what we evolved to was defense in an employment agreement that turned into a 40-page contract, and we were proactive in how do we protect ourselves from the regulators, and how do we protect ourselves from who this person potentially can be that can undermine a medical facility. So with that said, my question really is to speak to your discussion about the democracy versus, because we're in a republic, and I find that what Congress has created in these commissions and agencies is anything far from the Founding Fathers' intent of a separation of powers. These have inefficient, table-pounding powers that me, way down here in medicine, just do not know what to do except defend myself. But the last thing I think we have is a voice.
Yeah, so, okay, so the separation of powers point, right, was between really the legislature making the law, the president, Title I, president executing the law, so the president doesn't make the law, nor does any of the agencies that are part of that executive branch, and then the courts applying the law, right? So that's your separation of powers. I think without a doubt, Congress has passed lots of laws that then our agencies are required to implement through regulations. I think it's definitely I think it's almost like a default situation in terms of Congress that when they pass another law, they don't necessarily do the performance review of the past laws. You know, so they passed the Americans with Disabilities Act 1990, they passed the Family Medical Leave Act in 1993, did not necessarily think, now how are those two going to interrelate? You know, but ultimately, and then they're given to different agencies to enforce. Right? EOC is enforcing ADA, Department of Labor enforcing FMLA. That's a problem. Now, there are some of us in government who actually would like to make things as coherent as possible. I feel that, personally, I'm very lucky to have a colleague on the commission, Commissioner Lipnick, who was Assistant Secretary of Labor in the last administration, the Bush administration, for 7 years, knows a lot about FMLA. She and I have spent a lot of time trying to figure out, is there anything we can do in terms of, executing to make it more coherent? But ultimately, like I said before, it's not our job. It is ultimately Congress's job, and democracy is what it is. I still like it better than any other system. Thank you very much.
But that's not the issue. I mean, the question is, could we improve it? And the difficulty here is manifest. The general laws are stated in very broad terms, giving enormous discretion to the people to whom the power is delegated, so that every time you have a shift in administration from Democratic to the Republicans, you have an enormous flip-flop. That flip-flop increases the uncertainty with respect to people and businesses who are trying to make long-term changes. And so the original design of the Constitution, which was basically intending to try to stop these kinds of administrative agencies because of the risks that they've done, that's the flaw. So I do believe in representative government, but I don't believe it in its current form. I think it's a form of limited government in which you have both legislative power on the one hand and strong protection of private rights on the other, and that you can't talk about this model with only talking about the one half without worrying about the other. I mean, there is supposed to be a constitution, and it is supposed to protect people, and when we decided not to protect economic liberties, we made a serious and major mistake, the price of which we are still paying today. No.
We have a question. We have a question on this side of the room.
In thinking about particularly the comparison between the United States and Germany and the stagnation in both hiring and firing, the rise of unpaid internships, a possible apprenticeship model, I'm wondering if there are any similarities or analogies between that and a feudal system, and if so, what the implications would be for our earlier framing question of the livelihood of the American dream.
Oh, I'm in favor of serfdom, right? The feudal system's actually much more complicated than one might think, and it survived only in the early stages because of freedom of contract, and then it failed because the excessive levels of delegation that you had with sub-infeudation made it very difficult to operate. And so we have to take a lesson from the failures of feudalism and not replicate them today in the way in which we try to regulate employment markets.
I thought it was the Black Death that put an end to the feudal system.
No. It didn't end until 1660, and the Black Death was 1349, so there's a little bit of stuff going on. Remember, Magna Carta was around only for 150 years at that time.
Any other takers?
I guess I should say something on this because, I'm very much a believer that in the long run, we want to go with our system of high competition, lots and lots and lots of employers out there. That is the thing that will save employees. And all the things that Congress does, and, we love them, but nothing, it all pales in comparison to the importance of having lots of employers out there so that there is competition for employees and employees know that they can leave. But the downside of that for us, and I want to say it truly is a downside. And what employer in this country is the best one for vocational training?
What, McDonald's? Which one?
Come on. The Army? The military, right. The military, because if they train you and put a lot of work into that and then you walk, they arrest you. The downside of our system, and again, I think our system of as much competition as possible is no doubt in the world is the best. But the downside of it is that we have rotten vocational training. And the Germans beat us on that. And it's very hard to get public colleges and universities to do the right thing here because they're not very good at vocational training because they're not working in the industry. And it's not in their interest. They can't figure it out. And we need to improve on that. But if it's a question of trading our system for theirs, no way. Their union system, strong union system, gives them better vocational training, but it commits employees to working within that union forever in ways that I think are very, very, very counterproductive. But let's think about how we're going to do the vocational training if we're not going to do it through feudalism, essentially.
I thought I was hearing Gail Harriott endorsing what sounds like maybe a little bit of a feudal system with the military training, but I understand that that you don't want that.
There's no draft to get in there, but.
That is true. It is volunteer. But I would say that the predominant influence on opportunity is in fact aggregate demand and not these nuances of labor regulation. So to the extent that you look across Europe, for example, at the labor markets, what you see is places that are suffering from very, very low aggregate demand have horrible labor markets. And it is certainly true that across the southern tier, there are labor regulations that are so stifling as to be way beyond the range of what I've been talking about, and certainly that we have in the US.
Are you uttering the K word, Keynes? I'm just curious. Because I think, in effect...
No, actually, I think monetary policy has been quite effective at boosting aggregate demand. This is not a panel on macroeconomics. My point is solely to say that when you look at the statistics on the performance of labor markets, on employment to population ratio, unemployment rates, employment rates, what you see consistently is that aggregate demand is the most important determinant. By far, it's an order of magnitude greater than any other effect. So back to whether Germany is a feudal system or something like a feudal system, I guess what I'd say is that the advantage Germany has had over the course of the last decade or so is pretty robust aggregate demand.
But I think aggregate demand cannot be understood independent of labor markets. So if it turns out you have high constrictions on labor markets like you do in the Southern Rim, what that does is it reduces take-home pay, and that reduces aggregate demand. And so what happens is the idea that you're going to stimulate aggregate demand by taxation, for example, and expenditures is always going to be a mistake because you stimulate it with the expenditures and you depress it with respect to the taxes, so it always turns out to be a complete wash. You will improve both demand and supply, reduce uncertainty, and you could reduce uncertainty by getting rid of the erratic natures of some of these labor markets, and that will change the demand side. Because remember, the guys who are buying in one capacity are working in another capacity, and if you screw up one side of the market, it's going to make itself evident on the other as well. So I don't think we can separate these things in that nice way. This is the doctrine of internal connections, the thing that we actually started with when you talked about all the imperfections in labor markets.
Okay, we're going to try something different where I'm going to take 2 questions and then let the panel answer. You have so many of you that want to ask questions, and I want to make sure we get to as many as possible. So, yes, sir.
My question is on the idea of internships. I've had 7 different fellowships over my undergraduate and graduate career, including one that worked with 50 separate nonprofit placements in which we were all grouped. So I personally know probably over 300 interns at more than 60 organizations. And I can tell you that, we're going to hear some wonderful speakers over the next 3 days. We're going to hear from policymakers, from judges, from any number of people. But in a conference on millennials and the rule of law, we're not going to be hearing from any millennials. And as people who believe in distributed information and markets, I would ask the panel how we can incorporate more information of millennials in their positions, how employers can speak to them, because I can tell you that many of the people I worked with, the number one complaint was, we get paid with our letter of recommendation. And that means we can do absolutely nothing to our entire internship to risk making anyone upset. So all our needs kind of have to be shoved under the table if there's the slightest risk. Now, I've been lucky to intern at places that there were no problems, but I imagine people don't have that luxury all the time.
Okay, and then we have another question across the room.
You want to hear my question?
Yes,
sure.
and then the panel will
it's
respond.
directed primarily to Commissioner Feldman, and that is, I'm a Chicago trial attorney, and my labor and employment colleagues, all on the defense side, have indicated to me since 2009 there has been a real ramped up initiative on the part of the EEOC in terms of investigations, prosecutions, et cetera. How does that square with your observation that they're just merely interpreting the law of Congress? I raised my hand during the representative democracy part, and I think our culture is actually informed by my grandfather's namesake, Edmund Burke, who pointed out that the legislator's first duty is to apply his judgment as opposed to, and I paraphrase, rubber stamping his constituents' desires. So thank you.
Okay, I'll respond to that. I just want to say one thing about both internships apprenticeships, at least with the, the Americans with Disabilities Act, which I think was a very important law in terms of prohibiting discrimination against people with disabilities, really did very little to dent the high unemployment rate of people with disabilities. And lots of reasons for that, but part of it is non-discrimination can only go so far. So I do believe that the apprenticeship programs that exist, which have been elevated actually in the last number of years, going beyond the unions to more general locations, has been very important for those of us who care about getting people with disabilities into competitive middle-class jobs. So just want to say that I think that is an important arena. What Congress did in passing Title VII of the Civil Rights Act of '64 was say that you may not discriminate on a basis of certain characteristics, created the EEOC. So certainly if you would repeal Title VII, you'd repeal, the existence of EEOC. But if you believe Title VII should still exist, then query whether the agency that Congress actually put in to help employers, that is, before they could go to court, they had to be given the right to sort of have their charge investigated at the EEOC. Unlike a lot of other agencies where people don't have to come to the agency, the decision was made that everyone has to come through the EEOC first. I don't know that that was necessarily the best decision, but Congress made it. They haven't revisited it. And we're supposed to take in charges, investigate, conciliate if we find cause, and then in certain cases litigate. That was the charge Congress put on us. Now, there wasn't always enough money to do all of that effectively. There still hasn't been much more money. But one of the things that I and my colleagues did, starting from 2010, is come up, we did a performance review. We came up with a strategic enforcement plan that would have strategy behind it, and I think you're seeing that actually in all of the EEOC offices across the country, not just Chicago, that is actually now using this strategic enforcement plan to enforce the law as written, but in a proactive way.
Written by whom? By your own regulations. And the problem is there's so much deference to the regulations, there's so much wiggle room that you have exactly the problem that's done. There are massive changes in policy that you can do unilaterally that nobody else can challenge. And that's what gets people so distressed. And as best I can tell, every one of these changes, maybe I'm wrong, but I don't think there's a single one which says, gee, we used to enforce X, but we're backing off, we're only going to do half X. Can you tell me one thing that you've done which is less intrusive on labor markets than it was before you came on the office? I'm not aware of it. And I don't think anybody can tell me something.
Yeah,
that's what I want to hear.
Yeah.
One thing that you said, we should not enforce this.
Well, we can't say we can't enforce something that Congress has told us to do.
No, you have discretion on the
But your point about the
regulation.
flip-flops in different administrations, I don't like that. I feel that, there's a law that Congress passed. That law did not change when a new administration came in. I mean, I actually think it was a good thing that the reason Congress created the EEOC was they decided they wouldn't want the Department of Labor to enforce this new law or the Department of Justice, and they created a new entity that was a bipartisan commission. Now, I'm not sure as many people are committed to bipartisanship as both me and Commissioner Lipnick, but I'm glad that I'm serving on the commission the same time as she is because we have actually embraced that. So I think we have operated the way Congress has wanted us to. But we've got other questions.
But I need to make a comment there. I think that is definitely not true that the EEOC has acted the way Congress intended. I think if we were to go back to 1964 and show the members of Congress who passed Title VII what the EEOC became, even very quickly afterwards, they would be utterly shocked. One of the things that has bothered me particularly is Congress made a deliberate decision not to give the EEOC the power to issue regulations to private employers under Title VII. And instead, the EEOC naturally went to guidances because employers actually did want some guidance. It's not a terrible thing that they moved in that direction. But it turns out that guidances are a much abused thing. Yes. In the sense that things that actually should be regulations, because they are not what the statute says. The statute says don't discriminate on the basis of race or sex, et cetera. But we get instead these elaborate guidances that go far beyond what the statute actually says. And I think the criminal background checks is an area that's particularly egregious in this point. If we were to tell the people back in 1964, by the way, this is going to prevent employers from acting on criminal background checks, they're going to have to set themselves up in a situation where they can conduct the criminal background checks, all that's fine, but they can't have a strict rule saying we simply don't hire people with these categories of felons, and they're supposed to, under the guidance, then go to the employee or the applicant and say, well, we are thinking of hiring you. You have a conviction here. We want to give you a chance to tell us something about it. You're basically setting yourself up for the lawsuit at that point. You're telling the employee it's the conviction that's causing us not to want to hire you. So if you ultimately decide that you're not going to hire them, then you get the lawsuit. To say that this is simply what Congress desired, that is shockingly wrong. This is not what was anticipated by any means, and something needs to be done about the abuse of guidances, and they're being used essentially as substitutes for regulations by agencies that don't have the power to issue regulations in that area.
Yeah, I actually have written a long paper on this. The EEOC policies on this are unreal. And by the way, 3-2 votes, right, if I'm not mistaken, on party lines.
Okay, well, we're going to have our last two questions. But I do encourage you at some point, if you want to talk about the voice of the millennials, that was the previous question, because I don't know that anyone's talked about that, and so the millennials are not heard. But let me hear the other two questions, and then the panelists may respond.
I'd like to go back to the alleged empirical evidence that a burdensome regulatory employment regulations don't impact jobs. Particularly, let's talk about California. Yes, low-wage jobs, restaurant, retail, hospitality are created in California. Those types of business have to be in California because of the population. But do your numbers talk about the quality of jobs? Remember, in the Bush administration, those types of job creations were made fun of. When was the last time that a major company built a corporate headquarters or a new manufacturing plant in California? There's a reason Boeing built in the Carolinas instead. And I want to know, are these empirical studies actually looking at the quality of jobs that created? If I'm a recent graduate, I'd rather work in a Boeing factory than in a McDonald's.
Well, the answer is they don't take it into account, and they should.
Okay, and the second question that we have.
Yes, this is directed at Professor Epstein, but anyone can join in. I wanted to test your feeling about deregulation. Would you be willing to retain the title, I guess Title VII within the Civil Rights Act of 1964 that deals with anti-discrimination on account of race, given that the race classification is very different from all other protected classes, given the unique history of blacks in this country? Or would you say, having that provision actually causes distortions in the market?
Well, I mean, it's a complicated story, but I'm going to answer it. Today, you clearly want to repeal this. In 1964, there was so much embedded official government illegal segregation that, in fact, for the first 10 years, most of what the EEOC was to desegregate government agencies which had no business to do this. After 1975, the best we can tell, the statute has done no good for anybody in any way. And its first and most important implication on the private market was it slowed down the rate of affirmative action programs that might have otherwise had been taking place. And so one of the things you have to ask is when you repeal these statutes, what are you getting and what are you giving away? And I have done no empirical studies, but this is what I'm going to say. Affirmative action programs, on average, when voluntary, do a huge amount of good. Disparate impact litigation, when coerced, does none. And getting rid of Title VII essentially means the voluntary stuff can be freer and that the coercive stuff is gone. So it's an unambiguous improvement.
So the studies that I referred to about employment effects of employment protective legislation mostly focus on employment levels and do not talk about the distribution of jobs. And so I think that's a legitimate area of inquiry, and I think it's interesting to note that the sort of technology and biotech industry, information technology and biotech industries are extremely robust in California, despite two legal provisions that you might think would be problematic. One is the absence of enforcement of non-competes, and second is the rather intrusive, comparatively intrusive, employment protective legislation. So I think that's quite a legitimate question to ask, and it is undoubtedly true that companies in making location decisions do seek out jurisdictions in which they will have fewer legal constraints.
There is, yeah.
That's absolutely true.
The non-compete is a very interesting thing. I think Ron Gilson did a study, and it turns out that if everybody has a non-compete clause in there, you're worse off than if nobody has one. And it turns out there's a classic employer kind of prisoner's dilemma game, and that's one of the few cases in which a restriction on freedom of contract, I think, actually might be able to work. So California is actually pretty good on that. The rest of the labor statute...
Someone needs to tweet that right now.
But I've said this all the time.
Richard just endorsed the restriction on contract.
Well, I said they might well be good in these cases, and the evidence seems in that case to be pretty good. But the rest of the stuff is those unemployment, the statutes simply don't apply to startups and so forth. Minimum wage laws are not particularly important in Silicon Valley. And so what happens is it's a relatively unregulated labor market. But what happens is the people who are leaving California are not the very, very rich folks. It turns out that they're sort of mid-level people, and they're heading off to red states, chiefly Texas, Idaho, and so forth, because the labor markets are much better there. And we did not mention one other thing which is going to kill this, which is the increase in the part-time jobs is heavily a function of the Obamacare. If you're at 30 hours or more, you're a full-time employee. Understand, for somebody at $15 an hour, that's basically 133 hours of work that you're going to have to pay by way of a mandate. That's going to really have an effect, and it already seems to be having one. And I mean, I hope that you do a study on this, because it's a big enough, discrete event that my guess is you will find some fairly strong negative results. I hope, at least.
Well, I promised a lively discussion, and we have had a lively discussion. I think if we want to hear from the millennials, we need to just look at the Twitter feed today. Let's give our hearty thanks to the panelists.